So, hi, everybody. My name is Elizabeth White. Please call me Lizzie. I'm here with my colleague, Nora Kenty. We are both housing attorneys, specifically practicing in the Bronx Housing Court and serving Bronx tenants. We're thrilled to be here to present a little bit about Housing Court 101 and what the heck is going on right now in our post-pandemic landscape in spring 2022. We both work for Mobilization for Justice. Mobilization for Justice is a nonprofit legal service organization. We've been serving low-income New Yorkers since the 1960s. We do a whole bunch of stuff, including foreclosure prevention, immigration work. We do education law for folks with special needs, a whole number of things. But our biggest practice by far is our housing practice, and we practice in the Bronx, Manhattan, and Brooklyn. So just to give you a little overview of what we're going to be doing today, can everyone see our slides? Good. So our presentation is going to be split up into sort of two different sections today, and we hope that it's super helpful to you guys. The first part of the presentation is going to focus on what is going on specifically in housing court right now. What post-moratorium protections exist, what happens when you go to court, what you can expect right now. After that section, we're kind of going to go into a little brief overview about what types of cases you will see in housing court, how to respond to those types of cases, what sort of rights you can assert, and things like that. Okay, we're going to give a couple of breaks or small question breaks throughout the presentation. There'll be a slide that'll say questions. So we do ask that you hold your questions until that point in time, and you can put them into the chat or unmute yourself and ask those questions. Otherwise, we find it gets a little cumbersome if people start shouting them out or putting them into the chat as we go along. All right, so with that, I'm going to hand it over to my colleague, Nora.
Great, thank you so much, Lizzie. So yes, thank you all for introducing yourselves in the chat. It's great to see you all here today. Feel free to put your questions in the chat. We won't get to them until the question and answer portion. And it's best to ask more general questions as opposed to very specific, case-specific issues. But we'll try to get to all the questions people have today. I also want to share a handy document that we created that has a bunch of links to different sites that we find pretty helpful in our practice and can hopefully give people, a starting point to find information that they may need. So please feel free to visit that document and click through the links, see if any of them are helpful for you. Okay, so let's talk about how housing court is operating now. The eviction moratorium expired on January 15th of 2022. So we are in the post-moratorium world where cases are moving forward. And unfortunately, some evictions are happening. There are a lot of protections still, which we will get to. But let's talk about what a housing court case looks like. Courts are open in person. A lot of appearances are still virtual via Microsoft Teams, or you can attend by phone, but be careful because some appearances are in person mandatorily. If you are instructed to go to court in person, we recommend that you do so unless you receive permission from the judge or court attorney or clerk that you can definitely appear virtually. There are also some specific requirements of which appearances have to be in person. Lizzie's going to get to that in a minute. When you get to a courthouse in person, they're a lot emptier than they used to be in our experience. Sometimes in the mornings, they can be a little busy, but as the day goes on, it's really just a few people around. There's still full staff of court officers, and they're able to answer questions about where things are. In Bronx Housing Court, the parts have totally moved and changed around, and different offices are used for different things now. I had to adjust myself. So we definitely recommend, checking all the signs in the lobbies and outside courtrooms and just asking court officers for help. When you go in, you'll have to submit to a temperature screening, which isn't usually particularly useful. Sometimes it registers me as clinically dead, but you'll have to do a temp check just to make sure, and then you'll be able to go into the courtroom. They used to, have give attorneys secure passes so that you could bypass the metal detectors, but they're not doing that anymore. So everybody goes through the metal detectors. But the lines have not been as long. One place where you can expect to wait is at the clerk windows. I think they're still a little bit short-staffed on clerks, and they're still training a lot of new clerks that have been hired during the pandemic. So things are taking a long time to file or to ask for court records or questions like that. So be prepared to wait, and maybe have to talk to a few people at the clerk windows. Also make sure that you're proactive about getting what you need from the clerk windows. If you're an attorney filing a document in a case, you may need to ask for your copy of the document to be stamped to show proof that you filed it. It may not happen automatically. You may need to ask for those things and follow up. So just be diligent and make sure you ask for what you need. In terms of how to find out if you have court dates, the court is sending out notices, both the postcards that they used to send, but also full letters in envelopes. And those should tell you either whether it's an in-person appearance or whether it's virtual. And if it's virtual, how to appear. It'll actually write the Microsoft Teams link right on the notice. Most of the case filing is online now. It's using NYSEF, the New York State Courts Electronic Filing System, I think it stands for. Yep. So a lot of cases are filed electronically, which makes it easy to look up papers and kind of track the case and what's going on and what's been filed. But they don't show court dates on NYSEF. So you can see all of the documents that have been filed in a case, but you will not know just from NYSEF whether there's a future court date and when that future court date is. You have to go to eCourts for that. And I suggest that anyone who can set up an eTrack account so that you can kind of just have a docket of all your cases with upcoming court dates listed right there.
Yep. Okay. All right. So how does housing court operate now? How to appear? Again, we covered that. Virtual, some appearance may be virtual on Microsoft Teams or by telephone. I believe in the handout that we gave, the materials that we submitted beforehand, we might be able to drop that in the chat. There are a list of Microsoft Team links and phone numbers. You can call the part directly to find out how to check in a particular part. All right, so for some appearances now, effective March 28th, so just this week, certain types of appearances are mandatory as per Judge Schneider, who is the head judge of the New York City Housing Courts. Okay, all trials, any trial must be in person. Okay, if there's a specific need to proceed virtually, that will be a case-by-case basis. And you'll have to deal with that in the judge or whatever case is going on, but just assume a trial is going to be in person. You have to go to the court physically. All HP cases, so HP cases are cases that tenants or HPD bring against a landlord for repairs or harassment. If one of the parties does not have counsel, whether that's the landlord or the tenant, they have to be conducted entirely in person. All cases in small property parts, we don't take care of those as housing attorneys, but small property cases, they have to be in person as well. Okay, and now this is a little technical, but all cases assigned to resolution parts in Manhattan and intake part 1 and 2 will be heard in person on the first appearance in the resolution part. Okay, so then if there's attorneys, they may adjourn it in person or virtual, but that's up to the judge. So you're going to have to assume that the first appearance of the case is going to be in person. Right, Nora?
That's what they're saying. What they're doing is a little unclear, to be honest. Even cases that I thought, or appearances that I thought had to be virtual, it's mandatory. The court attorney even told me, we have no discretion. You have to come in person, no questions asked. The other party appears virtually and it's fine. So I'm the only bozo who goes to court in person. I don't really know what the protocol is. Some judges, I think, are allowing virtual appearances where other judges are not, but I don't want to risk it. I don't want to default. If I'm instructed to go in person, I'm going in person. So that's what we advise.
Correct. So if you've had a case, if you're a tenant or you're someone who's working with a tenant, they had a housing court case that was on before the pandemic, and all of a sudden they have a court date coming up, go in person. That is the best bet to make sure that nothing goes horribly wrong. If it's a brand new court case that has been started during the pandemic and it's the first court date you've had, go in person until told otherwise. Okay. Nora's going to talk a little bit about reasonable accommodation requests. What if you cannot go in person physically or for some other reason?
Right. So there may be cases in which any party or an attorney or anyone involved in the case needs a reasonable accommodation due to any sort of impairment that means the court needs to adjust somehow to take that into account. The reason that we're talking about it today in depth is because there has been a lot of work with the courts recently to adjust this process to make it more inclusive and fair and compliant with the Americans with Disabilities Act, or the ADA, including the fact that now the courts allow you to put in a reasonable accommodation request using this online form that we've linked to in our PowerPoint and also in the resources handout that I linked to earlier.
I'm going to share that again.
This is a new process for the court, especially the online request form. And there are groups that are monitoring how it's working. We don't want there was a lot of discussion with the courts. You have to implement a reasonable accommodation request portal or like method for people to do it to be compliant with the ADA. And the court said, fine. But if the court created this process and then they're denying all the RA requests, then that's useless. So we're really trying to monitor what's going on with these. If you face any opposition whatsoever, please reach out to us because we will put you in touch with a group that's advocating for these RA requests with the courts. Okay, so you can use the online form. And when do you use it? So you don't necessarily need a disability or a diagnosis to get a reasonable accommodation. Any impairment that substantially limits a major life activity requires a reasonable accommodation. That can be, for example, orthopedic, visual, speech, hearing impairment, a disease that's not immediately apparent, like cancer or heart disease or diabetes, or emotional or mental illness, or an intellectual or learning disability. Those things all count under reasonable accommodation law. And the court must find a way to accommodate, or at least engage in the process of trying to find a way to accommodate it. Other kinds of physical or mental disorders or conditions can also qualify if they substantially limit activity important to daily life. So it's worth asking if you think that something may qualify. If you are any person with any impairment who needs an accommodation relating to a court case, you are entitled to one at no cost to you. Again, worth asking. And this applies not only to parties to litigation, but to attorneys, witnesses, jurors, and spectators, anyone involved in the court process. There are a couple different types of reasonable accommodation requests. One is more administrative and one is judicial. The court administrative staff can't make decisions about a case, like whether a case is going to be heard in the afternoon or in a particular courtroom. That gets decided by a judge. And that's fine. That's a type of reasonable accommodation request that you can certainly ask for. But we do want people to be aware that if you request a judicial accommodation, the opposing party in your case may be made aware of it, because judges have to kind of notify all parties to a case of any changes or communications for the most part. So just be aware of that. Types of accommodations include providing assistive listening devices, an American Sign Language interpreter or any other interpreter, a CART transcription for people who are deaf or hard of hearing, copies of court documents in large print or audio formats, relocating the entire proceeding to a different courtroom that's more accessible if the person has a mobility impairment, helping to fill out a court form for someone who has trouble physically writing, and permitting the use of service animals for people who require them. So those are just some examples. Again, we suggest that you kind of root around in the new ADA section of the NY Court's website, and see if an accommodation would apply, because we really do want people to try to utilize this process. There's a link to it, and let us know how it goes.
Okay.
Oh,
All right.
and of course, sorry, if a litigant does have an attorney, the attorney may be able to appear in court for them. So it could help solve any of these accommodation issues in certain cases.
Yes, that's what I'm going to talk about in the next slide. I'm going to plug getting an attorney, because getting an attorney, the landlords and anyone who frequents housing court knows that the landlords do not go to court. Their attorneys go to court. So a great way to not go to court is make sure that you get an attorney. So in all eviction cases right now, we have universal access to counsel has rolled out in all zip codes in New York City. So what the court is supposed to do on your first appearance is there's supposed to be a legal services representative there appearing as a friend of the court. And they're supposed to get you're supposed to get a referral to that organization. So they will contact you shortly after your court appearance to do an intake and see if you qualify. So just to keep that, it's any tenant under 200% of the federal poverty line qualifies for a free attorney. Okay. Things to know about in that first appearance: the intake parts, as they're called, are not run by judges. They're run by court attorneys. So it really is for the purpose of connecting tenants to attorneys. Okay. That first appearance after the intake part is in person, as we talked about before. When in doubt, show up in person. If you have questions about how to get an attorney you don't have to get an attorney prior to showing up to court. One is going to be appointed to you, or you're going to get information how to get attorney when you show up to court, and you have a right to adjourn the proceeding to get an attorney or to seek legal counsel. But if you have questions about that, you can call 311, ask about the attorney program, and you can also just contact legal services directly, providers directly. Okay. Yep. So something to know right now, unfortunately, because of all of the cases that are rearing back up in the housing court, a lot of legal service providers are very overcapacitated right now. We don't have a lot of wiggle room to take on new clients, so things may be delayed, both in court and getting representation. But don't freak out, don't self-evict, don't sign things that you don't want to sign. It just will take longer than maybe before the pandemic to get you all situated. Okay, when you're filing an affirmative case, like an HP case or a harassment case, you can contact a legal service provider and see if they will help represent you. Again, just to kind of word to the wise, since we are over, we're at our limits just taking on eviction cases, it might be hard to get an attorney to represent you in an affirmative case, but that's not a reason why anyone shouldn't take their landlord to court. All right, so I know I saw some questions in the chat. That's kind of, I think that's our section about how housing court is running right now. So if you have questions about what to do if you have a housing court case right now, in the post-pandemic world, now is a great time to drop those questions in the chat, and we will do our best to answer them.
I see a question about secure passes. So they are the Office of Court Administration is giving out secure passes. Courts just aren't letting attorneys use them. So get your secure pass. Maybe one day it'll be good again, but right now everybody is required to go through the temperature check and metal detectors.
I think I see a question about immunocompromised folks and clients. I'm not sure. What I would say definitely is that something that you could bring up with the judge about why your appearances should be remote going forward. And I think that's something that they could accommodate. Again, if you're immunocompromised and you qualify for attorney, I would highly recommend getting an attorney, and then the attorney can appear in court for you if they won't make some sort of exception.
Yeah, and again,
go ahead.
Oh,
Nora.
sorry. The ultimate test is whether any impairment affects a significant activity in your daily life. And I think if you can trace anything being immunocompromised to impacting your daily life, maybe it means that you can't really leave your house right now because of the fear of COVID. And if you were to catch COVID, it could be fatal. That could count. I think that would be a good basis for requesting a reasonable accommodation. So I think you want to make that connection clear in the request. You need to connect the impairment, whatever it may be, with how it impacts your daily life. And then, make the request for how the court can accommodate you. If what you need is for the appearance to be virtual so that you don't have to leave your house, then that's the type of accommodation you would request. There may be some back and forth where the court or the judge kind of discusses with you, would this work? Would this work? Okay, we can do it virtual. Do you want to do it by phone or video? What if you have an attorney? Can they come in person? There might be a discussion, and that's perfectly legal. But you want to kind of request what it is you're looking for.
Yeah. I have to say that a lot of the judges don't necessarily want to have want to go back to the craziness that the housing courts were before the pandemic either. And most judges that I've been in front of are super happy and are automatically giving, remote appearances going forward. But just make sure you dot your I's and cross your T's. I see a couple more questions I'm going to try to answer real quick. Is this Zoom meeting helping landlords? I'm a landlord. Well, I mean, I think there's information to be gleaned for everyone from this presentation. I mean, I think that the rules apply about how a landlord appears in court versus not a landlord. It may be a little bit biased because we are all on, both me and Nora are on tenant side. But yes, I think that this could be helpful for a pro se landlord or a small landlord, for example. All right, are legal service providers giving advice if they cannot represent for HP? Absolutely. I mean, I think that's also what we're going to do if we can't represent people right away, is we'll be able to give you advice as how to proceed in whatever type of case that you do. So connect to a legal service attorney. Is there attorney or service for NYCHA tenants? Yes, there are. That's part of our work. We staff the NYCHA part in the Bronx. And yes, absolutely. You are income qualified if you live in NYCHA, and we represent NYCHA tenants all the time. What's the best way for a client to obtain a lawyer if their landlord takes them to civil court? Very good question. I would, again, that is a case where I don't think that they are automatically giving you a right to an attorney, like they are or access to an attorney as they are in housing court. So in that case, I would call 311 and reach out directly to service providers, because that is not something that the court is going to provide you with necessarily in the civil court. Okay, so now skip a few. These are some very specific questions. So again, we're going to try to ask that you not give case specific questions. Those are good questions to reach out to 311 or legal service providers, but any sort of broad questions we can answer. So Nora just put a list of free legal service providers into the chat. It's also on that Google Doc that we shared with a bunch of other stuff.
And
so
I
NYCHA, Go ahead, Nora.
I will just say briefly, anytime you are requesting a reasonable accommodation or an adjournment, or you're checking whether something is in person or virtual in court, do it ahead of time. Don't do it the day of the court date. You have to, the courts are honestly inundated right now with email requests, and there's no guarantee that somebody will see your email or anything if your court date is that day. So you definitely want to do it ahead of time.
NYCHA tenants, you can reach out directly to legal services providers. You can call 311. NYCHA cases, in housing court specifically, you are going to be appointed or try to be connected with an attorney on your first appearance. All right. We're going to move on, I think. Okay, so defenses, we're specifically now going to talk about defenses to housing court proceedings. This is a little more tenant friendly for any landlords out there after the eviction moratorium, but good for landlords to know.
Okay, so the eviction moratoriums, as I mentioned, have expired. There was a national eviction moratorium, which I think was ended by the Supreme Court. And then there was a New York State moratorium imposed by SEFPA, otherwise known as the COVID-19 Emergency Eviction and Foreclosure Prevention Act. That had an eviction moratorium that was triggered by the filing of a hardship declaration. Now, if you file a hardship declaration, it doesn't prevent eviction and it doesn't stay the case anymore. So eviction cases can go forward. But there are still things that are left that can protect tenants from eviction. Those include the Tenant Safe Harbor Act, which Lizzie will dig into more in a moment, but I'll just give a brief overview that it basically means if someone can show that they had financial hardship during the COVID pandemic, and that time period is defined as from March 7th, 2020 to January 15th, 2022, they are not subject to a possessory judgment, which means that while a landlord could get a monetary judgment, if somebody owes $10,000 and all of that money accrued from March 2020 to January 2022, the landlord can get a judgment saying, I can collect that money, but they can't get a judgment for eviction saying, I can evict you if you don't pay that money. And Lizzie will go into more of the details on how to plead that defense and how to raise it and how to prove it. Another defense that's available to tenants is ERAP, the Emergency Rental Assistance Program. That's a federal program, ERA, and in New York State, it's called ERAP. They are still accepting applications, and any pending application stays a case, whether it's a non-pay or a holdover. The only exception is nuisance cases where the landlord can prove that there's, really severe ongoing hazardous conduct. But for every other type of case, an ERAP application stays it. Right now, there's no money being given out because New York State is out of money, but we expect there to be a reallocation of funds nationally, probably next month. In April, after the New York State budget is due, but we don't really know when, but we do expect to see some more money devoted to that program at some point in the next few months. The way that nationally, I won't go into it in real depth here, but nationally, the money wasn't necessarily given out in a per capita way. So even though New York State is 33 times bigger than, say, Wyoming, New York only got 7 times more funding than Wyoming. So if Wyoming doesn't use up all its money, that gets reallocated to states like New York that have a lot more people or a lot more pending applications. So we may see more money being doled out by that program in the future, but right now it still serves to stay cases. I'll also note that there is an administrative order issued by the courts. It's AO 244/21 that requires, it's a mandate for landlords to inform the court when they know that there's an ERAP application that's been filed or when they receive ERAP money. I have never seen a landlord inform the court when they receive ERAP money. So I am not seeing compliance with that AO 244, and I encourage people to raise it and to monitor compliance and to require compliance. That landlords need to let the court know when there's a pending ERAP application or when ERAP money is approved. Okay, the next offense is the CARES Act. So there was a moratorium, I think, on evictions in the CARES Act that expired, doesn't exist anymore, but there's still a requirement that 30-day notices must be sent to every tenant that's in a federally funded or federally subsidized building before an eviction case can be brought. That provision of the CARES Act did not sunset. It is still in effect. And in fact, we just saw a case out of a Texas court dismissing an eviction case for failure to provide a 30-day notice in a public housing apartment pursuant to the CARES Act. And we've included that Texas decision in our PDF materials, as well as the brief that the tenant's attorney filed, which has some really helpful language about the CARES Act. So we encourage you to take a look at that. To find out if the building is federally funded, there is a really helpful CARES Act property lookup website that's in our Google Doc resource materials. And essentially it's all buildings that are subject to like any NYCHA or HUD funding. So any public housing apartments, any Section 8 apartments, homes that have a Fannie Mae or Freddie Mac mortgage, anything with LIHTC, any federal funding streams that come into an apartment, mortgage included, mortgage to the owner, falls under the CARES Act. And using this website, you can actually look up whether a particular property falls under it. And that essentially means they have to comply with a 30-day notice requirement before an eviction case can be brought. Okay, sorry.
Oh, could you, when you have a chance, could you drop in the PDF into the chat?
Yeah, absolutely. The last important defense that we want to mention is actually SEFPA. So SEFPA expired on January 15th, 2022, but for cases that were commenced when it was still in effect, they must comply with all of the requirements under SEFPA. So I encourage people to keep a lookout for cases that were filed between December 2020 and January 2022. Essentially, cases filed in 2021 are subject to the requirements of SEFPA. That includes, very importantly, a due diligence service requirement. Normally, landlords in eviction cases only have to make reasonable efforts at service. That's the word I'm looking for. They have to make a reasonable application to serve the tenant before bringing the case. SEFPA required due diligence, which means the landlord essentially has to try more than 2 times to serve the tenant. It has to be on different days. It can't all be during working hours or outside of working hours. It's just a more stringent standard. And I'm seeing a lot of cases filed in 2021 where there were only 2 attempts at service, and that does not meet the due diligence requirements. And there have already been several court decisions in New York City dismissing eviction cases for failing to serve with due diligence, or failing to adhere to these SEFPA requirements, even though SEFPA has expired. So don't discount SEFPA, even though it expired January 15th, it still has power, and essentially any cases filed in 2021 have to comply with it. So definitely recommend keeping an eye out. Okay, so kind of in a nutshell, there are a whole bunch of administrative orders and DRPs that have been issued by the court. They're very confusing, but it can all be whittled down to essentially the rules on the screen. Cases started before September 2021 and judgments and warrants issued before September 2021, landlords have to file a motion on notice to the tenant before proceeding with the case or proceeding with eviction. Even for cases where there was a warrant issued, the landlord needs to make a motion to actually execute that warrant. They can't just go ahead and execute a warrant that was issued back in like 2020 or early 2021. For cases that were started after September 2nd, 2021, it's presumed that they comply with all of the requirements. and the courts are allowing those cases to move forward. There can be a final judgment, a warrant, the warrant can be executed. I will say that there's still protection against default judgments. In order to get a default judgment, there needs to be a motion. And that's what DRP 222 says. Tenants and their attorneys should still make a really big effort to go to court. You don't want to even risk a default judgment. It just means if you don't show up, you lose the case automatically. It's a terrible outcome and it's not worth it. And it takes a lot of work to undo a default judgment. So definitely try to show up. But a landlord has to make a motion on notice to the tenant before getting a default judgment right now. If there is a judgment on default or in any other way, you'll need to file an OSC now because there's no other protection against eviction. And technically, marshals can execute warrants of eviction. OSCs can be filed on NICEF.
I can't talk to you right now. I'm in the middle of.
Thank you for muting. Okay, OSCs can be filed on NICEF or in person. However, word of caution, if you file an OSC on NICEF, email the court as well. Either email the judge in that part or email the head judge in your county. OSCs filed on NICEF, there is absolutely no guarantee a judge will see it that day. If the eviction is scheduled tomorrow or the day after tomorrow, you could be screwed because the judge didn't even see it filed. Email the order to show cause as well as uploading it to NICEF. If you file the order to show cause in person, seeking to vacate a default judgment or seeking to postpone an eviction, then you should be good. You don't have to email it as well. The judge will definitely see it if you do it in person.
Just a point of clarification, an OSC is an order to show cause. Any side can file an order to show cause. It's an emergency motion to the court to have an immediate court date set up as soon as possible. Usually in housing court, it's filed when a warrant has been issued and a notice of eviction goes out and you need to stop that eviction. That's most often when we file, when we would see an order to show cause or an OSC, as we like to say. Okay, so I am going to talk a little bit about ERAP for those of you who are not familiar with it. Again, it is a program that will assist in paying 15 months of rent for the pandemic period. So it's the Emergency Rent Assistance Program. It's the New York State program, which will provide a one-time payment of rent, and it can pay, and I know this was asked in the chat, it can pay utilities as well. So when you apply for ERAP, you apply for both rent, back rent, and any utilities arrears owed. Okay, you and your household must be at or below 120% of the area median income. You are obligated to, again, this is rent as your primary residence, so it has to be your house or your apartment. You need to demonstrate that you were harmed by the pandemic or experienced reduction of income due to the pandemic and financial hardship. That can be demonstrated by pay stubs that show loss of wages, if you received unemployment benefits, things like that. There is no restriction on immigrant status for an ERAP application. It doesn't matter if you're a US citizen, it doesn't matter if you're a green card holder, it doesn't matter if you're undocumented, you can still apply for ERAP. I was just thinking about income documents. If you have a letter, if you write a letter that says, I lost income during the pandemic, or I had increased expenses due to XYZ, sign it and notarize it, that will count. Your own sort of statement as to what happened financially to you during the pandemic will count as proof of harm, financial harm. What this will do on an eviction case, if you file an ERAP application, it will pause the eviction case. It will pause it. Does not mean it will solve it. Does not mean it will end it. It does not mean that you won't ultimately have to pay something to be able to solve the case, or that you will, if in a holdover case, it does not mean that you won't move out, but it will stop the case for the time being for the ERAP application to be processed. I'm seeing a question here. Okay, so it will pause that case. All right. So if your landlord accepts it's a two-sided application, and a landlord can also file an ERAP application. They can file one for their tenants and try to get back rent. It doesn't have to just be done by the tenant. If the landlord accepts the funds, you cannot be evicted for the period covered by that payment. And you should get it. They can't evict you. They can't start a holdover proceeding if it's non-payment case. They can't start a holdover proceeding you for 1 year thereafter, and they're not supposed to increase your rent for another year. It's supposed to be at the same amount as it was for that ERAP application. However, you should know that landlords can refuse to cooperate. The case will still be stayed, and the landlord can make arguments why it shouldn't be stayed, but they do not ultimately have to accept the money or accept the application, and then ultimately you could be in trouble for all that money. Again, I think I saw a question in the chat regarding the Tenant Safe Harbor Act. Again, you could make an argument for Tenant Safe Harbor Act and try not to be evicted. And you could argue you can't be evicted for the money that was owed if you can demonstrate financial hardship, just like during sorry, this is not making sense. I'm going to talk about the Tenant Safe Harbor Act in just a second. I'm getting ahead of myself. Again, as we discussed, there is no money currently in the funds for ERAP. We do anticipate that it will be replenished. We're very much hoping so, but there is no processing. Oh, another thing to note is that people who are living in Section 8 or NYCHA housing, arguably, there's nothing that stops you from applying for ERAP. And if you apply for ERAP, that will hold your housing court case, but not, to my knowledge, and I don't know if there's any other legal service providers here on this chat, they have not processed a single application. No money has been issued to any tenants living in NYCHA or having a Section 8 case or who have Section 8. So you might want to think about that before you fill out an ERAP application. If you live in NYCHA or you have Section 8, you may not ever see that money. No one has come out and said that, the program is not going to give money to tenants who have these subsidies, but it seems like that's in effect what is happening right now. Sorry, I got a little bit ahead of myself because they're kind of similar. The period of money that you can get relief from under ERAP is covered by the same period that the Tenant Safe Harbor Act kind of covers, right? So you can apply under ERAP for arrears from any time between March 7th, 2020 and January 15th, 2022. That's the same period that's covered by the Tenant Safe Harbor Act. Initially, the Tenant Safe Harbor Act was something that you could appeal to not be evicted, but that doesn't work, or to stop an eviction and stop the housing court case, pause the housing court case. What the Tenant Safe Harbor Act does now, in effect, is allows you to raise a defense, a financial hardship to the non-payment case. And if proven, again, it's a little complicated, it could bifurcate a judgment. So say you owe $10,000, $5,000 of that accrued before the pandemic, and the other $5,000 happened during the pandemic, from the period of March 7th to March 2020 to March 15th or January 15th, 2022. What you could argue is because that you had financial hardship due to the pandemic during that period, the only amount that you need to pay to stay in your apartment is that $5,000 that was owed prior to the pandemic, or for February and March now that were after this period. To prove, so what you need to do is you need to prove financial hardship. So things to consider: your income before and after COVID, what your bank account looked like before and after COVID, if you received federal, public assistance before and after COVID, like food stamps, if you received disability income before and after COVID. Unemployment benefits are a great way to prove that you lost a job or were laid off, or something happened to your work during the pandemic. That's pretty straight up proof that you suffered financial hardship, or any other sort of way that can demonstrate income change during that time. If you submitted a hardship declaration during your housing court case, that is considered a presumption that you suffered hardship during the pandemic. And an ERAP as well, if you applied for ERAP, because part of the ERAP application is that you have to show financial hardship during the pandemic. That is also a rebuttable assumption that you are covered by the Tenant Safe Harbor Act. So something to think about if you haven't raised it before is that if you applied for ERAP and you submitted a hardship declaration, the Tenant Safe Harbor Act may protect you for any arrears that occurred during the pandemic, or what we're calling the pandemic period. Okay, again, that means that they can't evict you for that amount of money, but they can get a monetary judgment against you that could affect your other parts of your life, but they won't kick you out. They can't kick you out of the apartment for it, arguably. Okay. All right, and we just talked about that a little bit before. Nora covered that, so I'll do that very quickly. The CARES Act, again, it's a federal act, and it demands that you have to send a 30-day notice is required before bringing an eviction case to any federal subsidized housing. And as we said before, that includes NYCHA apartments, that includes Section 8, whether that's administered by HPD, DHCR, CVR, any other type of project-based Section 8, Freddie Mae and Freddie Mac mortgages for any homeowners. And we have included, there's a link here on the PowerPoint and in our materials. You can look up to see if your building is a building that receives federal subsidies. You should get a 30-day notice prior to an eviction case. All right, that was a lot. Do we have any questions about the protections that folks have right now?
So the Tenant Safe Harbor Act is a complicated law, but the text of the law is actually pretty short. I pasted some of the text of the law into the chat. It goes on to say how a tenant can prove financial hardship, because that's necessary in order to get the benefit and protection of the law. But hopefully that helps. In kind of evaluating whether you want to raise Tenant Safe Harbor Act or not, it's worth thinking about options of paying back the rent. If there's no way that a tenant can get any help paying that rent back and they need to stay in the apartment, Tenant Safe Harbor Act may be your best bet. If a tenant is on public assistance or SSI and is what we call judgment proof, meaning a debt collector can't garnish their wages or assets, Tenant Safe Harbor Act may be a good bet, because even if there's a monetary judgment against the tenant, it's honestly not going to have too much of an effect. For someone who's working, their wages could be garnished, and their finances could be pretty significantly impacted if there's a big money judgment that they're not able to pay back. So that's worth thinking about.
Yeah, you have to kind of think about the strategy of your case, or, you know, whether you're a tenant or an attorney. Is the goal to stop the eviction right now, or is the goal to get rid of this potential financial judgment you have against you? Which in housing court, you know, it's both. Could you go? Okay, regarding Con Ed portion of ERAP has been paid. Okay, so this with ERAP applications, we had applications we filed months and months and months ago. Some of like the rent money got paid out, and now just now we're starting to see the Con Edison payments go through. Right. So if you applied for ERAP months and months ago and you still haven't received any news about the Con Ed portion, I would recommend calling the ERAP hotline and asking them what's going on. But we don't have any clarification exactly. It's just, it seems that they've processed it months later, that they're kind of addressing the rent concern first and then the Con Edison concern second. You can always apply. I mean, the great thing about the ERAP is that in theory, you don't have to pay that money back. It's a grant, unlike a one-shot deal. But if there are issues with Con Edison, you know, maybe just if it's immediate emergency, apply for a one-shot deal from HRA first or instead. What happens in a case where the landlord refuses to accept the money? If they refuse to accept the money, if to accept ERAP, then the case, you could maybe, you could assert a Tenant Safe Harbor Act, but the case would proceed as a normal case. It would take time, but you couldn't. I don't know. Do you have any thoughts on that, Nora? If they don't accept the ERAP money?
Yeah, so I think it depends on what kind of case. You can't bring like a non-payment case for money that was like part of the ERAP application if you reject the ERAP application. Holdovers, maybe. A landlord may be able to continue with holdovers if they reject the ERAP application. The ERAP statute does address some of this, but it hasn't been litigated much yet. So we don't exactly know what would happen. It could be the case that a landlord who rejects ERAP could be unable to collect rent for that, for the entire time period of the pandemic. We're not really sure how a judge would rule on that or how they would decide that issue, and it depends on what kind of case is being brought.
I also see in the chat there were some questions about this before and after September 2nd, 2021 issue. So I'm going to bring us back to this slide. Okay. If there is a housing case where that was started before September 2021, or a judgment and a warrant was issued prior to that date, to be able to execute on a judgment or warrant, the landlord has to have a motion in front of the court, and the court to get court permission to re-execute that warrant, that judgment and warrant. If the case started after, so it started September this year and a judgment was issued, there is no protection on that. Any court cases that started after September 2nd, 2021, where a judgment and a warrant was issued, the court is not automatically stopping that. There's no halt. It moves forward just like a normal case. You can be evicted just as normally after you receive the notice of eviction. There's no protection there. Are there any other questions? Does that clarify people's questions about that?
I definitely recommend looking at the most recent administrative order is AO 35 of 22. And AO 35 is really helpful, I found, because it includes as exhibits all of the other AOs and DRPs that are still in effect. So you can kind of, if you have a case that's in this gray area and you don't know whether the landlord's supposed to bring a motion or not, it's worth going to AO 35 and kind of looking through because the time periods do matter. For the most part, though, that before September 2021 and after September 2021 distinction is the case. Anything before that, before September 2021, there needs to be a motion and it needs to go before the court in order for any sort of movement toward eviction to be made. For cases that were like prior to March 2020, pre-pandemic cases, those are all being conferenced. Those have to go back to court before anything can happen on them. They're being conferenced automatically by the court at this point. I mean, some of them aren't, but they're working on it. For cases where like a judgment and warrant was issued, if the landlord wants to actually execute that warrant or get a warrant from that judgment, they have to bring a motion to do it. After September 2021, they no longer have to bring a motion in order to execute on a judgment. There just can't be a default judgment without a motion. Right now, there's still some protections against default judgments. However, the landlord brings a motion for a judgment, for a default judgment, there's going to be a court date, and if the tenant doesn't show up on that court date, a default judgment could be issued along with a warrant of eviction, and an eviction could happen. So even though there are still a lot of protections in place, unfortunately, it is a possibility now for evictions to go forward.
And that kind of reminds me too, if you do apply for ERAP or you have applied for ERAP and you were awarded 15 months, which is the full amount you can get under ERAP, the landlord then does have to make a motion or otherwise notify the court to bring that case back to the court, and it'll be back in front of the court. If they don't, it may just sit there indefinitely until the court gets around to rescheduling things.
Ernesto, I see you've had some questions about an illegal apartment. So apartments that are subject to vacate orders by either DOB or HPD aren't really housing court issues. Those are like HPD, DOB issues. If they issue a vacate order, there's really no way around it. I don't think any housing court, any housing lawyer can fight a vacate order, unfortunately.
Nope. It's kind of deeply unfair, but there's nothing anyone can do that's just directly from the city.
But doesn't the landlord have to provide another place or
No.
expenses for moving out and so on and so
No.
forth, like I read?
No.
If you call the Red Cross or HPD, they'll often be able to provide a hotel, usually for like a couple days or up to a week. But I'm not aware of any rule that the landlord has to provide relocation.
Well, on the HPD website, I did read that because of the illegal use apartment, that they would be liable for moving me out because of the vacate order and paying for my relocation expenses in the apartment or hotel room or whatever the case may be that I've been relocated to.
I don't want to get too far afield with this because this is a fairly specific question. That may be the case, but how do you go about that? Obviously, you can directly contact your landlord and talk about it, but I feel that this is probably something you might have to sue for civilly to try to get that money, because it's not something that you would have a remedy for in housing court.
Yeah, that was one of the options that was presented through HPD because of the previous landlord collecting 14 and a half years of rent, knowing that this was an illegal use apartment. Okay, it's supposed to be a 2-family, and they were renting it out as a 3-family. So that to me sounds like fraud. And yes, that there's a lot of facets to my situation.
Oh, yeah, I have to, and I unfortunately have to stop you so we can continue on with the conversation, but that's definitely, if you want to talk later, get in touch with us later about what you can do. But again, that's outside of the scope of what the housing court and housing attorneys can probably help you with.
Okay, how would I do?
We will give you our contact information at the end
Okay.
of this presentation, or call 311. When in doubt, call 311. All right, so just quickly before we move on, because we are running out of time and we have a little bit more to talk about, what constitutes permission that landlord needs for default judgment right now is the judge saying, okay, they need a hearing, and the judge saying, okay, that's all the permission they need, is the judge's sign off on that.
And the judges are supposed to be looking at whether the appropriate notices have been filed and whether service happened correctly. There needs to be an affidavit that someone from the landlord's office called the tenant and inquired whether anyone is in the military. It's called a non-military affidavit. But sometimes judges kind of do a quick review and they think it looks okay, and then they allow the default judgment when they're kind of like really hard to find defects or things missing. Or maybe, a landlord was supposed to have complied with the CFPA service requirements, as I mentioned, based on when it was commenced, but they didn't. But that's like, those are all kind of technical things, and a judge may not have time to really dig into each and every case in full detail. And that's why having your own lawyer can be helpful, because they can really dig into whether all of the requirements may have been met for the landlord to get a judgment of eviction.
Yeah. We have a question, 2 more questions, I think, about ERAP, and then I'm going to cut that off there because we're at 3:32 and we have a little bit more. talk about. What do you do or suggest how a tenant can see if their landlord complied with letting the court know that they received an ERAP award? Again, so it's a good question. If you apply for ERAP and you get the award, you will also get an email that says the amount that you got the ERAP, how much it was for, what months it covered, and at the end of the email is the notification that they send to your landlord. The landlord then has to make some sort of motion to the court. That would be put on to NICEF. That would be on NICEF. However, if they're going to have another hearing, they have to serve you with notification. The court has to notify you that there's going to be another hearing on the matter post the ERAP, receipt of the ERAP. Does that make sense? What other options do clients have who are granted the 15 months of ERAP but still owe money? That is the big question that all of us are dealing with right now. That's what the program gives. It gives 15 months, although the pandemic was 2 years. That's all they pay for. So if you still owe money, you can apply for a one-shot deal application. You can seek grants with Help USA Home Base. You can reach out to Catholic Charities. You can reach out to Coalition for the Homeless. There's a whole swath of other charities within the city who could help assist with that. Get a friend, take a loan. You have to pay them money, figure out how to pay them money somehow. Is mediation playing a role in any of these matters? Mediation, no. In my understanding, if a landlord takes you to housing court, you go to housing court. And I don't know any landlords, and I would love to find out if any landlords were actively entered into any sort of mediation. Okay, I keep putting it down, but I know we have new people who join, so I'm just going to put that Google Doc right back in there that has a list of what other things you can do, or like other places you can apply for aid that is not ERAP if you've already applied and you've already gotten that money. All right, so now we've kind of concluded about what's going on with housing court right now, and we're going to just go through housing court 101. What is a housing court? Like, what housing court cases exist? How do I know what's going on with them, and what should I do with them?
Okay, so let's talk about just kind of a brief overview of the different types of cases we see in housing court. There's the landlord-tenant issues, which consist of non-payment cases for rent, and holdover cases for everything else. There are a lot of different types of holdover cases, and it essentially just means the case isn't exclusively about rent. There's also cases that tenants bring against landlords instead of the other way around. Those generally are HP cases for repairs or harassment. Occasionally 7As, which is a type of case in which the majority of tenants in a building come together to actually take ownership of the building away from the landlord, and illegal lockout cases, which can be against landlords or really anyone who performed an illegal lockout. You really want to look at the type of apartment for any given case, because the rules totally depend on what type of housing you're looking at. Rent stabilized and rent controlled apartments, which we call rent regulated apartments, have a lot of rules. Those are imposed by the state, and they give tenants protections from eviction. There has to be a good cause to evict a tenant in a rent-regulated apartment. The rent increases are limited. You can only increase the rent in rent-stabilized apartments by a certain percentage, and you can't increase the rent in rent-control apartments except under certain circumstances. Some apartments are not rent regulated. We call them unregulated. Some people also call them market rate apartments. And they're subject to a whole different set of rules. It's a little bit less strict. So you want to know, most small homes, apartments and like 1 to 4 family homes are unregulated, but not all of them. And you definitely want to look, especially given the pandemic era protections at whether there's any federal or state subsidies relating to the housing. If it's NYCHA Section 8, that should set off alarm bells that the CARES Act might apply because there's some federal funding at play. Even if it's a single family home, you probably want to look up whether there is a federal HUD mortgage, like a Fannie Mae or Freddie Mac mortgage, to see if that apartment is subject to the CARES Act requirement. And there are also some rules that are specific to different subsidies. So with Mitchell-Lama apartments, there should be an HPD certification process before a housing court eviction case. With NYCHA Section 8 tenancies, there's a whole long list of things that a landlord has to do. They have to notify NYCHA before bringing the case. They're supposed to get permission. They're supposed to, let NYCHA know about everything that's happening. If it's HPD Section 8, they're also supposed to put in the court papers, like this tenant has Section 8, and if they don't, that could be a defect. So it's important to look at what kind of housing you're actually working with in order to see what defenses are at play.
All right, so we're going to go through quickly the steps of an eviction case. First, there needs to be predicate notice, warning that the landlord is about to take you to court. They have to warn you the type of case and what the issue is, whether it's money, whether it's something else. Then you need to be served with a notice of petition or petition. This is what's also called the court papers. That's going to have an index number, and it's going to should tell you what you need to do and when you need to go to court. You will then, regardless of the court case, will need to put in an answer. An answer is more important in a non-payment case than a holdover, and we'll talk about that a little bit later why. If no one shows up, if nobody answers or shows up to the court date, there will be an inquest or a default entered. Oops. If everyone gets the predicate notice, the notice of petition, they answer, goes forward. The resolution of the case will either result in a trial. You'll go to trial and the judge will decide what happens in the case, or someone will submit a motion and the judge will decide what happens with the case, or you will settle the case. The two parties will sit down and agree on what needs to happen, and that's how the case will be solved. In housing court cases, judgments are the ultimate goal of the landlord who is bringing the tenant to court. In housing court, is twofold. It is, in a non-payment case, it is both possessory and financial. They're trying to get the rent and they are trying to get possession of the apartment. In holdover proceedings, it's mostly to get possession of the apartment, but ultimately they're looking for a judgment. And once they receive a judgment, they can receive what's called a warrant of eviction. After a housing court case, when there is a warrant of eviction, to execute on that warrant of eviction, it will be sent to a city marshal, and the city marshal will then send the tenant a notice of eviction, warning them that within 6 business days they will be evicted. If you receive a notice of eviction, that is when you would file what's called, we talked about briefly before, called an order to show cause, or an OSC, which will stop and halt the evictions shortly for the parties to return to court and try to talk about what's going on, see if they can't resolve it again. If that doesn't work, or if there's no order to show cause entered, then the city marshal can come and change the locks and make a formal eviction. So I just got served. What do I do? What does it mean to be served? All right, so I talked about predicate notices. In a non-payment case, the predicate notice that you must receive is called a rent demand. And we have a picture of a rent demand. It's redacted, so you don't know who it was sent to, but here on the side. And the purpose is to let the tenant know that if they do not pay the amount listed, it has to list the amount that is owed and for which month it is owed in, that if it is not paid within 14 days, the landlord will start a housing court case against you. A predicate notice for a holdover proceeding is called a notice of termination or a notice to quit. The predicate notice purpose is to provide the tenant with notice before they start a housing court case And again, these predicate notices are not eviction notices. Even though it says they can start it, it's just to warn you that the landlord is going to bring you to court, and they have to send you these documents first before they actually go to the court and get an index number and get that all started. If the tenant doesn't leave, right, for a rent demand, if you do not pay within the 14 days of receiving this notice, the landlord can start a housing court proceeding in a notice of termination or notice to quit. If the tenant doesn't leave the apartment by the date stated on the demand, the landlord can start the housing court case. Another notice, that predicate notice, is called a notice to cure. This is for a holdover. I should say a notice to quit or termination notice means when a landlord isn't renewing a lease. Say you had, this is for like a non-regulated apartment. If two-family home, you had a lease, the lease is over, the landlord doesn't want to renew the lease, they have to send you a notice that they are not renewing your lease, and that if you don't leave by the date that they state, they can start a holdover case. Or if you are living month to month in an apartment and whoever is in charge of that apartment, they have to send you this to let you know that they are no longer want you to live there, and they're starting a holdover proceeding. A notice to cure is a predicate notice for a holdover when there's a lease or something, but there's a behavior issue. There's something happening in the apartment that is causing a problem, right? So the purpose is to let the tenant know to stop or cure that activity, whether it is, abusing a neighbor, being really, really loud and smelly, or lighting fires, flooding your neighbor's downstairs apartment, something along those lines. It's a notice to please stop that. All right. And then if you do not, the landlord then usually must serve a notice of termination saying that you have not cured the issue that's going on, and then they will send you a notice of termination. All right.
So once the landlord sends the predicate notice that's required, or predicate notices that are required, because usually more than one is required, but not always, then the landlord will officially start the case by serving a notice of petition and petition. They have to serve both of these documents on the tenant in order to start a case. And there are really specific rules for how they have to be served. They should be served on the apartment. They're usually, the best way to serve someone is to give them the papers in person, but there can be other ways to serve, like posting copies on a door, mailing, or serving somebody else who lives in the apartment. Or if the case was started in 2021, they have to use due diligence, and they have to try more than 2 times to serve the tenant in order to use due diligence service. Receiving the notice of petition and petition in a non-payment case triggers the time to answer. You have 10 days from receipt of these documents to file your answer in a non-payment case. And that can just be done right now by calling housing court and just doing your answer over the phone. I think that's a really great development that's happened since COVID. Or you can go to housing court in person and do the answer at the clerk's window like you used to be able to. Now, let's say a landlord has started the case by serving a notice of petition and petition, and then they want to move forward with the case. Maybe nothing was ever calendared. Maybe they brought this case in 2020 and it didn't end up going on the calendar because the courts closed, and it just never ended up anywhere. The next slide shows that the landlord may bring a notice of motion to try to get that case on the calendar, or they could bring a motion for other relief, like a final judgment. They could bring a summary judgment motion. They could bring a motion for a default judgment if they brought the case and the tenant never answered, or if the tenant never appeared, they would file a motion for a default judgment. And they, would have to comply with all of the requirements of getting a default judgment, which is showing service was proper, the affidavit of non-military service, as I mentioned before. There are a lot of different elements that are required. So let's say there's let's say a tenant applies for ERAP after receiving the notice of petition and petition, because they recognize that there's rent due, they're trying to get the rent paid. And then a landlord brings a notice of motion to put the case on the calendar or to get a default judgment or a warrant or whatever it is. There's an ERAP stay in effect. So what do? Here's what I've done as a lawyer. I show up to the court date that's scheduled after the landlord files the notice of motion, and I let the court know there's an ERAP stay in effect. If the case is on NYSEF, I'm going to upload proof of the ERAP application or an affirmation that an ERAP application has been filed to NYSEF. You want to provide some sort of notice to the court and to the other party. And I would show up and say, hey, I'm not really sure why the landlord made this motion because there's an ERAP stay in effect. What's going on? And the judge should say, oh, there's an ERAP stay in effect. This case can't go forward right now. I'm going to put this motion on hold. I'm going to put this off the court's calendar. We're not going to do anything with this case until an ERAP decision is made. That's what they should do. What the judge may do is say, it looks like the landlord is challenging the ERAP stay. I want to know whether the stay applies in this particular case. So I need you to file a response to this motion. I need you to file opposition or a cross motion, whatever it is. But you definitely want to show up, even if there's an ERAP stay in effect, to see what the judge wants to do, whether they want briefing and how they want to move forward.
Right. And I know that people were asking about, right, how do you ask for permission? This is how attorneys, landlords, how we ask permission of the court to do X, Y, or Z after the initial case has been filed. For a motion for default, I'm sorry, I'm going to answer this question real quick that I see. Can a tenant request an adjournment to connect with legal services? Yes, if you have not gotten an attorney prior to whatever the next date of court is, you absolutely can ask for an adjournment to connect with legal services. Please do it.
And the best way to defeat a motion for a default judgment is to just show up. If you show up at the next court date, there's no default, you have appeared. You may need to file an answer or something to make it kind of official. But if you show up and say, I'm here, I'm not defaulting, I would like a lawyer, please, then the motion probably won't be able to go forward. Okay, so finally, what a tenant may receive is a notice of eviction. And this is really serious. And if I get a call from a tenant, whether it's somebody I already represent or whether it's a new intake that I do, because occasionally, very unfortunately, tenants will only find out about an eviction case when they receive a notice of eviction. And it's shocking and it's really scary. And it's very serious. And I will generally try to set anything I'm doing aside to handle that, because a notice of eviction is alarming. Fortunately, due to the HSTPA, notices have to be served 14 days before the day that the eviction can happen. So you do have some time to figure out what's going on and prevent the eviction from happening. It used to be like a 72-hour notice, and it was a real scramble to get the eviction prevented. But now you have a little bit more time to file an order to show cause. Again, you can file it in person in court, or you can file it electronically via NYSEF and email, definitely email. And you want to show proof of why the eviction shouldn't happen. So you want to raise any defenses that you may have. You want to show why you need more time to move or why you need more time to pay. If you never showed up and it was a default judgment, why didn't you show up? Were you never served with the papers? Were you out of the country? Were you staying with someone due to COVID and that's why you couldn't come to court? Were you in the military? Is that why you couldn't come to court? There could be a whole bunch of reasons. So you kind of want to share what those are in the affidavit. And you probably want to connect with an attorney if you don't already have one and you receive a notice of eviction, because you may have defenses that could be raised. So what I have also found helpful is calling marshals, and the list of marshals is on the nycourts.gov website. They're usually really honest about when things are scheduled and what they are going to do and what they're allowed to do. It's definitely okay to call the marshal and say, hey, I just got this notice. I don't know what's happening. What do you have on your end? And they'll tell you. They'll say, oh, well, we got this request for a warrant. We're scheduled to carry it out in 2 weeks. And if we get an order to show cause signed by a judge, we're going to postpone that. So I definitely recommend, if you have any questions or want like a more firm timeline, to just reach out to the marshals.
And sometimes they'll be straight up, we're booked. We're not going to get to it this week or next week. And sometimes they'll also be like, oh no, we're evicting you Thursday at 9 a.m. And they'll give you the exact date and the exact time. All right. I saw a quick question. I get so distracted by the chat. If a landlord took an ERAP award payment, can they still ask ERAP stay be overlooked? So to be very specific, if you applied for ERAP, the stay only applies while the ERAP application is pending. If the landlord was paid 15 months out of the ERAP program, the stay no longer applies and the court case can proceed. Okay. Non-payment screening questions. All right. So this is for anyone, but really for practitioners, for folks in housing court answers who are trying to help a tenant, for attorneys, and good information for tenants to know too. So this is for a non-payment. What sort of questions should you ask yourself? What sort of documents should you look to see if everything has been done properly in your housing court case and where to go with it? All right. So for the court papers that you need, the documents you need to get. We talked about predicate notices. For a non-payment case, you need to get a 5-day notice. There should be a letter from your landlord saying that in 5 days, we've noticed you're not paying rent. 5 days, please pay. After that, you're going to get the rent demand. And we discussed the rent demand. It has to list all of the months that you haven't paid rent and the amount for each amount. It will say, if you don't pay within 14 days, we're going to start a housing court case against you. After you receive that, the landlord can then serve the notice of petition and petition upon you, right? Attached, they have to then enter, after they've served the notice of petition and petition upon you, they have to file an affidavit of service with the court that demonstrates that they served the rent demand and the notice of petition and petition on the tenant, right? It will tell you once you receive that notice of petition and petition that you need to answer within 10 days. You can answer in person if necessary or call. And a notice of eviction. These are court papers that you might receive. Okay, if you do not receive a 5-day notice, a rent demand, a notice of petition to petition, there may be a problem. You may not have been served properly. These are all things to keep in mind in a housing court case. If you are the tenant and you did not receive these things, or if you're the advocate and your client did not receive these things, it's a good defense to the proceeding in general. If the first thing that the tenant receives is a notice of eviction, something has gone wrong, and it's usually the landlord's fault. All right, documents that you're going to need if there is a court proceeding. You're going to need to collect your most recent lease, whether it's a renewal lease, and if you have possibly the original lease that you entered into the apartment, that also can be very helpful because it tends to be a lot longer and a lot more detailed than a renewal lease agreement. Rent history. If you're in a rent stabilized apartment, you can request the entire history of your apartment registered with DHCR, and an advocate can help you check to see whether or not the increases that your landlord has been taking are correct and legal. Proof of payment. You want to make sure that you have proof of payment for rent that you paid. Sometimes landlords send whole people into housing court for rent that was already paid, or they paid some of the months on the rent demand, but not all of them. Very important to make sure that you have any proof of payments you've made for the housing court case. If you have a subsidy, whether that is Section 8, NYCHA Section 8, it's HPD Section 8, DHCR, or CVR. If you're on public assistance and you receive shelter payments or have a FEPS or city FEPS subsidy, anything that documents what those subsidies are paying to your landlord is really important to have on hand. Some questions that you should be asking if you receive 5-day notice, rent demand, notice petition. If there's a housing court case, did you submit an answer? Have you applied right now? Have you applied for ERAP? Have you submitted a hardship declaration? Is there any evidence that refutes what's claimed in the petition, right? I get a petition that claims I didn't pay rent in April and in May of 2021, but I have proof I paid in April and May of 2021. Get that all together. Do you have a court date? When is the next court date? Okay. When do you need to go? Is it in person or is it in person or is it on Microsoft Teams? Did you receive a notice of eviction? If you received a notice of eviction, probably the first step you're going to do is an OSC. So these are just questions to keep in mind and ask when there is a non-payment court case going on.
Okay, so for cases that are not about non-payment of rent for holdovers, here are some screening questions that we frequently look to. Did the tenant receive predicate notices? And if so, what type? Was there a notice to cure? Is it a 30-day notice, 60-day notice, or 90-day notice, which could mean it's an unregulated apartment? Tenants who have been living in unregulated apartments for different periods of time are entitled to different lengths of notices. Is it a 10-day notice to quit versus a 30-day notice of termination? You want to kind of use these notices to figure out what kind of case it is. Usually the predicate notices will have the most detail about what the issue is that the tenant is being evicted for. And if there's no detail, then it'll probably just say the lease terminated and the landlord wants you to leave. You want to check if there has been an answer filed. Probably not, because answers aren't required to be filed right away in holdovers. You can file an answer pretty much at any time before trial. Just be aware that if you don't appear in court and you don't answer, you could be subject to a default judgment. But usually for holdovers, I like to collect a little bit of information before submitting an answer. Sometimes I will get the DHCR rent history to see if the apartment's rent stabilized and what the legal rent is. I'll try to get any, Section 8 documents. I'll try to look up the landlord's deed on ACRIS and any regulatory agreements and kind of make sure that my answer is pretty detailed in a holdover case. Even though an answer can be filed at any time before trial, it's good to do it fairly soon or judges just get upset. They'll kind of press you and say like, okay, what do you want to do with this case? I'm not just going to adjourn it forever. You want to look at the petition and see whether the apartment is rent regulated. So if it's rent stabilized or rent controlled or not. The petition should state whether it is or not. If it doesn't, that could be a defect. And if it's wrong, that could be a defect, but you want to look and see what it says. If it is rent stabilized or rent controlled, then there are particular requirements that a landlord has to state in the papers in order to move forward with an eviction case. So you definitely want to know that. And even in a so-called no cause holdover or end of lease holdover in an unregulated apartment, there could be a lot of defenses. So there's no guarantee that you'll be able to stay in the apartment long term, but the landlord still has to comply with the requirements of service. They have to comply with any subsidies or programs or funding that they're receiving. And a lawyer can help you look through those defenses and see if any apply to your case.
Okay, so we are at the 4 o'clock mark. So we will try to go very quickly through these. And if it is 4 o'clock now, so if you can't stay, feel free. It was great to have you guys. If you need to leave, that's fine, but we're going to carry on for just a little bit longer. All right, I can't pay my rent. What do I do? What do I do, Nora? We just talked about this. All right, how do you get assistance in paying rent? There are a couple things right now that we're recommending tenants to do. One-time payments, we are recommending that if you have not already, apply for the ERAP program, right? Even though there isn't money right now, it'll stay your house. We don't know when the next round of payments going to come from them. It will pay 15 months that you do not have to pay back, and it will pause your housing court proceeding. I see a kind of a question in the chat that's pertinent to that. If you get paid out 12 months, only 12 months of the program 12 months during the ERAP and you believe that you should have been received 15 months, yes, reapply and put a stay on that housing court proceeding. So it's a good way to go about that. HRA one-shot deals, applying to public assistance for a one-time loan to cover rental arrears, applying to private charities. I'm going to just drop our resource. I keep doing this, drop our resource handout in there. Subsidies. You can apply for ongoing rent subsidies, Section 8, FEPS or city FEPS. Section city FEPS and FEPS being state assistance by HRA that helps pay arrears and will help pay rent going forward. You can apply to charities and in community-based organizations such as Home-Based, Coalition for the Homeless, Catholic Charities. All of these programs help, all of these organizations help give small grants. Things to be aware of. Generally speaking, if the rent that you owe is above $10,000, that might be a problem for achieving a one-shot deal or getting assistance from other agencies like Home-Based or Coalition for the Homeless. If you cannot prove that you can pay rent going forward, you're also going to have an issue getting a one-shot deal from HRA or getting assistance from community groups and charities.
Let's say someone comes to you and says, or you're experiencing, my landlord is harassing me. There are a few different things that this could mean, and there are a few different things that can be done. This could be about repairs. It could be about other harassing conduct. It could be an illegal lockout. Those are all types of cases and actions that can be brought by tenants against landlords. If you want to bring a case for harassment, you bring an HP case. An HP case is also what you bring for repairs, and usually I blend those two together. If I bring an HP case, I'll often raise the repair issues and I'll raise a harassment claim. The reason is that the failure to make repairs, to make essential repairs, can be a form of harassment. So they're very related to each other. And also harassment damages can include money, whereas it can be difficult to get damages. I think it's impossible to get damages for repairs in an HP case. There could be damages for contempt, but that's another story. Okay, so on the next slide, it kind of, I think, says a little bit more about these types of cases. So if you bring an HP case for repairs or harassment or both, you first want to document your requests to the landlord that repairs be made. The first step is always letting your landlord know that there's a problem. You need to show or be able to testify to the fact that you told them. It's best to tell them in writing, either with a text or email or letter, so that you can show the exact date and you can print it out and show that you informed your landlord of the problem. Then usually the next step that I tell people to do is call 311, put in an HPD complaint. HPD will come out and do an inspection. Worth noting, I mean, some people in this training have raised that if it's an illegal apartment, HPD could place a vacate order, so be careful about that. Also, if you inform your landlord of repairs and they don't do the repairs, you may be able, if you want, to make the repairs yourself and pay for them and then deduct them from your rent. That's a whole process, so it may be worth talking to an attorney about your specific situation if you want to do that, but it is an option. If HPD finds violations, then that is considered prima facie evidence of violations of the Housing Maintenance Code for the purposes of an HP case, which is a fancy way of saying it's kind of automatic evidence of violations in court. So HPD violations are really helpful. And I think calling HPD is an important step usually in getting repairs done. So then once you have the documented request to your landlord, but they still don't do the repairs, you've called HPD, they place violations, then you can bring an HP case. Again, because many tenant legal service providers are totally at capacity right now with eviction cases, we don't have as much capacity to take HPs, but you can file them pro se in housing court. And I think the housing court clerks are pretty good about telling people how to do service of HP papers. You have to serve the landlord and you have to serve HPD. They're both parties to the case. And you want to make sure you serve them correctly or the whole case gets thrown out. At the first appearance of an HP, you can go ahead and seek an order to correct or an interim order. Sometimes the case will just be adjourned for repairs to be made, but we do encourage people to ask for an order to correct as soon as possible. The goal is to get an order so that if the repairs aren't made, there's a violation of a court order. And that can be really powerful. And we actually have seen a discrepancy between the Bronx and other housing courts in terms of judges' willingness to issue orders to correct. Whereas Bronx judges tend to just adjourn cases over and over for the landlord to have many chances to do repairs. Judges in other boroughs will issue an order to correct on the first appearance if there are HPD violations, really without much of a fight. So we are trying to push housing court judges in the Bronx to do the same. You want to serve the papers via certified mail, return receipt requested, or by personal service if the judge orders it. However the judge orders you to serve, make sure you do it that way and do it really carefully. And service can be tricky, but again, there are a lot of good resources and guides on nycourts.gov. And now HP cases that are sent out to trial go to the trial parts. They actually don't stay in the HP parts, which is a good development because that means that HP judges have more capacity to take more cases. But that means that your trial could be heard over at 851 Grand Concourse, where the trial parts for Bronx Housing Court are. In other boroughs, it'll just be in the trial parts in those courthouses. In the Bronx, it's strange because the trial parts are in like a totally different building down the street than the housing court. But any notices you get should specify where you're supposed to go. And illegal lockouts are much the same in terms of the fact that you can start them on your own in housing court. They'll give you all the paperwork. You have to take care of serving the papers on your landlord in the way that the judge says and by the deadline that the judge sets. And service is very important because if you don't serve it correctly, the whole case could get thrown out. But if there's an illegal lockout, just bring it as soon as possible. The sooner, the better.
Okay, so what if your apartment is unregulated and your landlord wants you out? So it's a small 2-family home. There's only 2 apartments in it. It is a market rate apartment. You pay a lot of money for the apartment. It's not regulated, something along those lines. All right, so things to know about an unregulated tenancy. Generally, the lease is the most important. It governs the terms of the tenancy. So if you have a lease, hold on to that. It will tell you what the landlord can or cannot do. If you don't have a lease, if it was simply an oral agreement, that makes it a little more complicated, but you still do have some basic rights. All right. So even if you're not in a rent stabilized apartment, all tenants have the rights to repairs, quiet enjoyment, to live there free from harassment and discrimination by the landlord. You are allowed to have roommates within legal limits, right? If there's like 2 bedrooms, it can get complicated, right? Subletting, you can sublet with the landlord's permission if you're not going to live there for a couple of, a month or 2, but you still need someone to pay the rent. All right, you do have the right to do that. If the landlord is going to terminate your lease or not give you, just decides that they want to have that apartment back, they do need to give you notice before starting a housing court case. If you have lived in the apartment for less than a year, they need to give you a 30-day notice, termination notice. If you have lived in that apartment for 1 to 2 years, you're entitled to 60-day notice. And if you have lived in the apartment for more than 3 years, you're entitled to a 90-day notice. Okay, notice and due process before an eviction. So if you are a month-to-month tenant, you get at least 30 days, right? However, you can see the chart above, but you get at least 30 days notice. If you receive a notice that has less than 30 days, that should be a big warning sign that something is not correct. The landlord is not serving you proper papers and you have a defense. And of course, retaliatory eviction defense to a holdover, right? Is the landlord just evicting you because you decide to complain to HPD about the conditions in the apartment? keep that in mind. That is a defense that you have. You know, we're in New York are working towards a good cause eviction bill and a right to remain in the apartment. We're hoping that will be passed, but that is not so that there are more protections for unregulated tenants, but that has not yet been passed. So keep our fingers crossed. All right,
Okay, so we're
Thanks for
nearing the
sticking with us.
end of our presentation, and then we can get to the last couple questions. Some important takeaways that we want to leave everyone with are: don't self-evict. Just because you receive a notice, that doesn't mean you have to leave. A predicate notice does not mean you have to leave. A notice of petition and petition do not mean you have to leave. Even a notice of eviction does not necessarily mean you have to leave, although it does mean a marshal is coming and you need to do something quick. So stand up for yourself, show up to court, get an attorney, be prepared for your case, and also be prepared for the judge to push you to settle. This goes for tenants and their lawyers alike. Judges don't want to write decisions. They want every case to settle, and always be ready for the judge to say, why can't this case settle? You should have a good answer to that question every time you go to court. We encourage everyone to apply for ERAP anytime it's appropriate. That is one of the best protections in New York State right now, and we encourage everyone to take advantage of it. Again, it applies to non-pays, it applies to holdovers, and it's a really good, strong protection. There was a quick question in the chat about whether you can apply for a one-shot deal and ERAP. Yes, you can. Right now, ERAP isn't giving any money out, so you can apply for both at the same time. There's a caveat that if you had an earlier ERAP application, like around maybe June to August or June to November, earlier, like in 2021, that HRA will make you wait until you get a determination on that before letting you do a one-shot deal, but just try it. HRA will let you know whether you qualify or whether you're able to apply. Show up to court, file an answer, especially in a non-payment case, definitely file an answer. Hold on to all your papers and your rent receipts. If you get an attorney later on and you have all your documents and all your rent receipts, they will thank you profusely. I will fall to the ground and kiss your feet if you have all of your rent receipts. It's so helpful to get a sense of what's going on, because a lot of these cases can turn into he said, she said, unless somebody's got the documents to prove what happened. Get information from any agency you can. Get the rent history from DHCR, get all the documents from Section 8, get the HPD violation record, look on ACRIS for the regulatory agreements. I can't tell you how many great nuggets of information I have found in regulatory agreements on ACRIS relating to different contracts that a landlord has with the city or with other parties, other agencies, with HPD, with whoever, that has really helped me in cases. And they're really painful to read through, but they're worth it, I think. Definitely try to communicate with your landlord, communicate with the court, a lot more. I'm communicating pretty regularly with a lot of court attorneys, with a lot of clerks. I'm emailing with them. They're pretty helpful. They're busy. They don't always get to my emails right away, but it's worth a try because I think open communication can help resolve a lot of issues. And never be afraid to make sure you understand what's going on. Confirm with the judge, whether you're a tenant or whether you're an attorney or a landlord, confirm with the judge what the next steps are. It's okay to repeat back and say, Judge, just to make sure I understand, is this what you're saying? Just so I understand, the next court date is this day at this time. And do I need to come in person or can I call in? Ask those questions, make sure that it's clear. I also like to use questions to kind of avoid red herring arguments. So let's say I have an illegal lockout case where the tenant was illegally locked out of their home and the landlord says, but they never paid rent. I may ask a question like, so are you saying people who don't pay rent deserve to be illegally evicted? And just asking the question can sometimes clarify, listen, that's not an issue that we are talking about here. That doesn't apply. That's not the law. Let's just get past it. And that's kind of the last thing that I want to leave everyone with. So now we can go to our final questions.
Thanks, guys, for hanging in with us. I know we're over time, but really appreciate it. And we hope that this has been helpful. And we're here to
I
answer
think
any
we
questions.
technically have till 4:30.
Oh, do we really?
I think so.
Great. Then we finished with plenty of time. I was had in my mind 4 o'clock. So yeah, please ask away. Okay, so I'm seeing some questions come in the chat. Retaliatory eviction, how many months after you call the city to complain would it be considered retaliatory if you get an eviction letter? I would say immediately. If you called the city and an HPD made HPD complaints and anything, if the landlord tries to evict you thereafter, arguably you have defense. Not like a complete defense.
I think it's up to a year after a complaint to a government agency is made that it can be considered retaliatory.
Let's see. Can you explain what a holdover case is? Okay, so a holdover case is a case that a landlord brings against a tenant that is not about rent. A non-payment case is just about rent, paying rent. A holdover case is a case, again, about basically anything else. Either there is no lease or the lease expired. That's one type of holdover case. There's the tenant is committing a nuisance in the apartment, like the tenant is damaging the apartment or causing harm to other neighbors. That is also a holdover case. So the holdover refers to any case that doesn't have to do, it's an eviction case that doesn't have to do with rent specifically. How long will ERAP protect you? ERAP will protect you only while your ERAP application is pending. And ERAP applications pend for many, many, many months in our experience.
And then if ERAP is granted, there is a provision of the statute that says a tenant who's been approved for ERAP and the funds have gone out can't be evicted in a no-cause holdover for 12 months. So they could have a different type of case brought against them, a non-payment for rent that was not covered by ERAP, for example, or another type of holdover. But that's also a protection that's provided. The due diligence standard of service. This is a little bit technical and will require some research into case law if you are filing a motion. But even if you don't have the case law, it's worth raising. What CIFPA said, and CIFPA was in effect during 2020, most of 2021. There was some time in August when the Supreme Court struck it down. So be careful of August 2021. For the rest of the year, CIFPA was in effect. And it said that in order to bring an eviction case, a landlord had to serve a tenant using due diligence. Meaning, if you try to serve a tenant once and they're not home, and then you try again and they're not home, you have to try a third time at least. And you have to try at different times of day. So it can't all be at noon when the tenant might be at work, and it can't all be at 10 p.m. when the tenant might be asleep. It has to be different times of day. Usually it has to be like 2 weekdays and 1 weekend. Due diligence is a pretty strict standard of service. So that's an example of like how it would apply. And again, once CIFPA expired in January 2022, those service requirements no longer apply. Now it's just reasonable application standard again. But for the period when CIFPA was in effect, the enhanced service standard applied.
Are clients responsible for late fees? Okay, so things to consider. All right, if you are a tenant and you are getting charged late fees on your rent, first thing you need to know is take a look at your lease to see if you consented to being charged late fees in your lease. Technically speaking, if you are charged late fees, you are responsible to pay those late fees, and the landlord could seek those fees in a plenary proceeding, say small claims court, civil court, something like that. For housing court purposes, ignore the late fees. Late fees are not considered rent. A landlord cannot evict you for not paying late fees. They can only evict you for not paying rent. when you apply for, different types of aid and whatever, you can try to include the late fees in there, that total amount, but ultimately what we're looking at is rent, and they will pay for the rent to not be evicted. I hope that makes some clarification, but you may still be responsible for those late fees in some other forum.
And arguably, if a landlord serves a 14-day rent demand that seeks late fees, that rent demand and the entire case that is based on it is invalid.
Defective.
Absolutely. In a non-payment case in housing court, an eviction case, a landlord can't seek anything other than rent.
Not a security deposit, not any, just rent. What to make of a landlord who in a holdover matter files a 5-day notice of monetary default?
Oh, that sounds like the RPL 235E notice.
Yeah.
That's interesting because those are required now in non-pays by the HSTPA. It's just a notice. It's like a notice before the 14-day rent demand that the landlord has to give saying you owed rent 5 days ago and you defaulted. I think they probably served it just to cover their bases. I don't know. It's not required in a holdover. It's only required in non-pays. So I guess they just like served one for fun.
Right.
I don't think it's like a defect in the case though.
Oopsie poopsie. They served an extra notice they didn't need to. Yeah.
In terms of delays seeking legal representation, this is a really big issue in New York City right now. There are not enough lawyers to handle all of the eviction cases that are going forward, let alone the HPs and illegal lockouts where people also need representation and there just isn't enough. What we're seeing is that if tenants show up to court and say, I want an attorney, judges are for the most part respecting that and they're letting the tenant have time to seek an attorney, but they're not going to grant indefinite adjournments. And we don't know exactly when we're going to reach the point where a tenant is going to be forced to proceed alone. We're monitoring it. So if you see it or if it happens to you, reach out to one of us and we will connect you with the Right to Counsel Coalition. It's a fantastic organizing group that is really on the front lines of ensuring that every tenant has a lawyer. So they are monitoring this closely and they're really pushing back hard with the courts to try to get them to slow things down so that people can get the legal representation that they have a right to now.
What happens if the landlord denies payment from OTDA? That means they deny payment. We kind of discussed that a little earlier. You can't force the landlord to accept payment they don't want, and the housing court case will proceed eventually once that gets sorted out.
But arguably, the landlord waives the right to collect that particular rent.
Right. For that period.
Again, we don't know how that's going to play out in courts, but because it's a new law, but the statute says if the tenant's approved for $5,000 and landlord says, no, I will not accept it, landlord can't go and seek that same $5,000 later. They may be able to seek other rent that's owed, but they can't seek that $5,000.
And I would argue that, again, that you try a Tenant Safe Harbor Act. If their, defense covers the same sort of period, if they're not going to accept rent during the pandemic period, they can't be you can't be evicted for rent that accrued during that pandemic period.
Oh, this is a good question. Does NYCHA have their own courts? No, but NYCHA has its own court room in each borough. So there's one judge that hears like all the NYCHA cases.
NYCHA. Does ERAP protect tenants in a holdover case? Yes, if you file an ERAP application, even though it's a holdover and the case is technically not about money, the case will be stayed. And if the landlord decides to accept your money, arguably, depending on what the holdover is about, if the holdover is about termination of lease and they accept the money, I would argue that you get to stay in that apartment for at least another year. If it's about something else, I mean, it might be a good thing to do, right? If you're in a really nasty holdover case about nuisance or some other issue, and you just want to make sure that the landlord continues to get paid while you're duking it out apply for ERAP, it'll stay the proceeding and they might get paid. Oh, nuisance, that might not protect you. But if it's something
nuisance
else.
holdovers are the only exception. It's a common misconception right now that an ERAP stay does not apply to holdovers. And I have seen many landlord attorneys argue this is a holdover. ERAP stay doesn't apply. It does. It says explicitly in the statute, this applies to non-payment cases as well as holdovers. It's right there in the wording of it. So it's a definite. The only exception is nuisance holdovers. There, the ERAP stay doesn't apply, but even then, you probably need a hearing before a judge to determine whether the stay applies or not.
Okay, so there's a lot of good questions here. But right, if there's like doing a non-prime or some other type of holdover, file ERAP, go for it.
This question, I received an ERAP award, but the landlord will not give me credit for partial payments I made for the months I got ERAP awards. They have to credit you for payments that you made, but they may be able to apply them to different months, I guess, depending on the ERAP awards. I don't see why they would need to. They could just apply it to the same months, give you a credit for those months, and then also apply the ERAP payments. Sounds weird, but I'm not exactly sure what that would look like.
Yeah, I don't know. Money is money, and they should just apply it to your bill if they're going to be funky about what months. It's an odd request, an odd thing. As a NYCHA resident, see many rents have gone up outrageously. I would need a little more context. NYCHA limits your rent to 30% of your income. And if your rent has gone up tremendously, you probably should ask for an interim recertification of your rent and present all of your income documents, expenses, deductions, etc. Because NYCHA rent should not go up outrageously all of a sudden.
Yeah, that's concerning to me as well. Definitely worth, if it's happening to a lot of people, maybe try and like get a tenant association together, get some information from lots of people and reach out to an attorney to kind of look and see whether it's a widespread issue that is concerning.
If money was owed before March of 2020, along with money owed during the pandemic, does ERAP still stay the non-payment case? Yes, it does. Doesn't matter where the money came from. If you're applying, when the arrears, if they're pre-pandemic arrears, pandemic arrears, the ERAP will stay it while the application is being processed. Do you know a why for NYCHA? That I don't know what that. Okay.
All right. Well, it's 4:30, so I think we're gonna let you guys go. But thank you all so much for coming and for engaging. I feel free to reach out to us by email. Sometimes it takes a couple days for us to respond because we get a lot of emails, but we will definitely look at them and try to help everybody as much as we can. Thank you.
Yeah, and I just wanted to, this is Sarah from Housing Court Answers. I just wanted to thank you guys for such an amazing presentation. Thank you.
Sure, thank you. Thanks for hosting
Thanks for having it. Thanks for all the work Housing Court Answers does too, because really, you guys do wonderful work. And yeah, if tenants have questions, ask Housing Court Answers. They're great.
Yes.